Welcome back to Uncivil Law. Ever wonder what happens when the law seems to take a turn that makes you scratch your head and say, wait, really? Well, buckle up today because we're gonna dive into that legal roller coaster that's got everyone talking. Guns, the Second Amendment, and a court case that's as controversial as it gets. This one will make you question what you thought you knew about gun law. So let's break down our subject today. We're talking about the Maryland Firearms Safety Act of 2013 and the court decision that recently interpreted it. You know, the law that decided to ban what it called military-style weapons, like the AR-15 and the AK-47. Now, if you're thinking, isn't that going a bit far? Aren't all those types of guns that law-abiding citizens use too? You're definitely not alone. And that's what makes this case so fascinating, and dare I say it, a little bit unsettling. Let's start with the basics of this lawsuit. The plaintiffs in this case were challenging the Maryland law under the Second Amendment, the right to bear arms, the one that everyone seems to have an opinion on. But before we get into too deep of a dive, let's get into a quick refresher of what we're dealing with here. The Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Sounds pretty straightforward, right? Well, as we know, nothing in the legal world is ever as simple as it seems. Over the years, the Supreme Court has taken a few cracks at this one with landmark cases like District of Columbia versus Heller in 2008, where they said, hey, the Second Amendment protects an individual right to possess firearms for self-defense, especially in the home. And they didn't stop there. In 2010, with McDonald versus Chicago, they made clear the Second Amendment actually does apply to states too. So far, so good. But then came Bruin in 2022, and that's where things start to get, well, let's say a little bit more complicated. The Supreme Court said, enough with this balancing test nonsense that you lower courts have been using. If you want to regulate guns, you've got to show it's consistent with the nation's history and tradition of firearms regulation. Translation? If George Washington wouldn't have had a problem with it, you're probably good. But if you're trying to do something new, you better have a really good reason for it and one that's based off history. And that's the lens which we're going to be looking at Maryland's law today. But was that lens really as clear as the recent court decision thinks it was? Let's find out. Okay, so what exactly did Maryland do to kick up this legal dust storm? Back in 2013, Maryland decided that they had had enough of shootings and gun violence, so they attempted to remedy this through the Firearms Safety Act. The law, however, didn't just nibble around the edges. It went straight for the heart, banning the sale, possession, and transfer of certain weapons it deemed military style or so-called assault weapons. We're talking about AR-15s, AK-47s, and even the Barrett 50 caliber rifle. Maryland's logic? These weapons, they said, were designed for military use, not for civilians. They said they're too dangerous, too powerful, and not necessary for things like hunting or self-defense. Maryland at least thought this sounded pretty reasonable, at least on the surface. But if you dig in a little deeper, you start to wonder, didn't Maryland maybe go a little bit too far? Are they throwing out the baby with the bathwater by banning guns that a lot of law-abiding citizens use responsibly? After all, the AR-15 is probably the most popular rifle sold in the United States. The plaintiffs in this lawsuit certainly thought so. They're saying, hold on, Maryland, you're stepping on our Second Amendment rights. These guns aren't just waiting in some armory waiting for the apocalypse. They're in common day use by everyday people for lawful purposes, like self-defense. And they didn't just stop at making a few complaints. They're challenging the entirety of the law. But the plaintiffs didn't just waltz into court with a generic laundry list of grievances. They went for the jugular with a facial challenge. Now, if you're not familiar with legal jargon, this is like saying this law is rotten to the core. This isn't just bad in some cases, like it would be in an as-applied challenge. It's bad in every single situation. A facial challenge. It'd be like walking into a restaurant and saying the whole menu is terrible no matter what you order. The plaintiffs in their lawsuit leaned on the common use doctrine, arguing that those weapons that were banned were popular among law-abiding citizens for self-defense. These aren't just toys for hobbyists, they're tools for protection. So Maryland's ban? Totally out of line, they say. But did the court see it that way? Not exactly. Now, this is where the majority's decision got a little bit, let's say, creative with their history lesson. They dive into the archives, pulling out examples from way back when trying to justify Maryland's modern day ban. But here's where the decision got shaky. The court starts by throwing off the old concept of dangerous and unusual weapons. This idea has been around since the days when folks were more worried about swords and crossbows than semi-automatic rifles. Back then, the thinking was just simple. Some weapons were too dangerous for the average person to carry around. But here's the catch. Those were different times with different weapons, and in today's Constitution, this phrase means something different. Fast forward to today, and the Court of Appeals majority seems to think the century-old concept justifies Maryland's modern ban. They're saying, hey, we've always regulated weapons that are too dangerous, so this isn't anything new. History and tradition, am I right? But hold on a minute. Was the court really comparing apples to apples? Or is this more like trying to compare an iPhone to a rotary phone? The majority is acting like history is on their side, but the majority might just be a little bit more complicated than they're making out to be. And it's not just about the AR-15. The court looks at other weapons like machine guns and sawed-off shotguns and says, see, we've regulated these before, and everything turned out fine. But then again, you've got to ask, are these really the same kind of weapons? Is the AR-15 really in the same category as a fully automatic machine gun? Or is the court stretching things too far to try to make an ideological point? It's like they're trying to fit a square peg in a round hole and calling the fit perfect. Now we get to the heart of the decision. How did Maryland's law hold up under the Bruin test? Here's where things get even more questionable. Remember, the Bruin test is all about whether a regulation or ban is consistent with this nation's history and tradition when it comes to firearms and the Second Amendment in particular. So the court asks, does the text of the Second Amendment cover the kind of weapons Maryland wants to ban? This majority actually says no, arguing that AR-15s and similar weapons aren't what the Second Amendment had in mind for self-defense. They're saying that these are military grade, designed for war and not home protection. Let's pump the brakes here for a second, Court of Appeals. The AR-15 is in common use today, just like the plaintiffs argue. It's widely used and widely owned. It's not some sort of exotic and rare weapon, and it's not just owned by people preparing for doomsday. So while the court outright says these aren't the type of guns that are even covered by the Second Amendment at all, is the Court of Appeals really sticking to the text, or are they merely rewriting it to fit their own narrative? And then there's the history lesson. The court attempts to pull out examples of past regulations, but are they really comparable? Sure, we've regulated machine guns and sawed-off shotguns, but the AR-15 isn't a machine gun. It's a semi-automatic rifle, and that is a big difference. After all, semi-automatic firearms are the most common firearms owned today. The court seems to be glossing over those nuances, lumping everything together under the banner of a dangerous weapon without really digging into any of the details. It's like saying all fast cars are the same, whether it's a mere sports car or a drag racer. Just because they're fast, however, doesn't mean they serve the same purpose. But hold on, just when you thought the majority had wrapped this up into a neat little bow, here comes the dissenting opinion, asking the questions that need to be asked. The dissenting judge was like, wait a minute, Maryland, are you sure you're not overreaching here? The dissent argued the Second Amendment should be interpreted more broadly, that just because a weapon is powerful doesn't mean that it's not protected. After all, isn't self-defense sometimes about having the most effective tool at the job? And the dissent doesn't stop there. They took issue with the majority's rejection of the facial challenge. The dissent said, look, not every situation is the same. Just because these guns are powerful doesn't mean that they're also dangerous in the hands of responsible owners. Maryland's law paints too broad a brush, and that's the problem. The dissent basically calls out the majority for oversimplifying things. They're saying you just can't lump all these weapons together and ban them without considering the real world. This isn't about banning something you deem to be a weapon of mass destruction. It's actually about restricting tools that people use in their day-to-day life for all kinds of lawful purposes, including self-defense. The dissent asks the tough questions, like, are we really protecting public safety here, or are we just infringing on the individual right without a good historical reason? So where does that leave us? The Court of Appeals' decision to uphold Maryland's Firearms Safety Act of 2013 pretends like it's rooted in a historical precedent, but it's not really. But what do you think? Are they just using the history as a convenient cover to justify a decision that feels more like a modern policy choice than a constitutional one? The majority seems confident in their historical analysis, but the dissent raises serious red flags. Are we really sticking to the original meaning of the Second Amendment, or are we letting our modern fears and biases shape our legal interpretation? It's not a question that's going away anytime soon, especially as debates of gun control continue to heat up in various courts of appeal. So what do you think? Is Maryland right in its ban, or are they stepping on our lawful rights? Do you think the Court of Appeals got it right with their historical analysis, or do you side with the dissent and think they're stretching things a bit too far? And when talking about a facial challenge, shouldn't the court have taken a closer look at the specifics before making such a broad ruling? We'd love to hear your thoughts. Drop your answers in the comment section below to get this conversation started. Until next time, I've been Uncivil Law. Remember to keep it uncivil out there.